right now, we got to talk about the huge Supreme Court case that came out yesterday about presidential immunity and how now President Trump can order SEAL Team 6 to murder people. This is the chair of the Biden-Harris campaign.
He continues to talk about trying to find a way to find immunity, if you can, for him to order SEAL Team 6 to kill political opponents. That ought to freeze everybody, in their tracks, right?
Yes, it ought to freeze everybody. It's also obviously not true. The great Ken Klukowski is here, Breitbart Senior Legal Analyst. Mr. Klukowski, how are you,
Good
sir?
morning, Mike. How are you?
Has there ever been a more absurd reading of a Supreme Court decision in your illustrious history?
It's hard to say because there's been some really whacked out, unhinged comments on Supreme Court opinions over the years. Though off the top of my head, I can't think of a commentary that is more stupid, crazy, counterfactual, or such a grotesque mischaracterization of an opinion that I'm really trying to figure out if they believe this or if they're gaslighting the American public. To me, I put it on the same level of telling the American people, like if this guy, Joe Biden is as sharp as he's ever been. He is just sharp as a tack. His mental acuity, that montage that you played earlier, it's like, okay, this is on that level of outrageously crazy, stupid, and obviously lying. The only question is, do you know you're lying, or are you trying to convince yourself of any of this? Are you drinking any of this Kool-Aid that you're trying to serve to the American people?
Yeah. I think it's all in the same pile at this point, right? It's just like, whatever.
It is beyond whatever we want. Though. It's not like, that's a reasonable position. I respectfully disagree. No, there's nothing reasonable about this.
Okay, now listen, it comes from somewhere. So this is in Judge Sotomayor's dissent. Let me just read this, and then we'll go back to the beginning. She says, the president, in her dissent, 6-3, she was on the losing side, the president of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution. Order the Navy SEALs Team 6 to assassinate a political rival? Immune. Organize a military coup to hold on to power? Immune. Take a bribe in exchange for a pardon? Immune. Immune. That's such a weird, that's like bizarre, but also like a weird way to even write that. Okay, let's go back to this. So that's Sotomayor. Let's swing back around. What is the genesis of this immunity trial?
Well, you're talking about the history of it or what the Supreme Court did with it?
Why did this even make it to the Supreme Court?
So this is one of the prosecutions, one of the 4 prosecutions brought against President Trump. And this one alleged what was brought to a D.C. grand jury, which is like, bringing it to a New York City petite jury or trial jury. And there were 4 charges, all associated with January 6th. And one was the 4 indictments were, and of course this is all about just everything that went into January 6th, where you had a protest that turned into a riot, and at that riot there were a number of individuals who, the video shows were clearly committing criminal acts, like whether it's striking a police officer or smashing a window of a government building, etc. And the 4 counts are conspiracy against rights, which is 18 U.S.C. 241, conspiracy to defraud the United States, and then also 2 counts of obstruction of an official proceeding. So actual or attempted obstruction, which is 18 U.S.C. 1512C, and then also conspiracy to obstruct, which is 1512K. And at some point, I'm sure we'll discuss that, the Supreme Court on Friday may have taken out both of those 1512 counts. In fact, pretty much definitely did. So that prosecution was brought in the D.C. district. The trial judge on that case is, I'm just speaking objectively here. I am an officer of that court. So it's not pejorative term, just a descriptor to say that just as Judge Carl Nichols, I would say, is probably the most conservative judge on that court, Judge Tanya Chutkan is, I believe, I regard as the most liberal judge on that court, and she's the one who was randomly assigned to President Trump's case. And there's been a whole range of pretrial motions that the president's legal team has brought. Those have all been denied to date by Judge Chutkan. It went up to the U.S. Court of Appeals, a couple aspects of it, to the U.S. Court of Appeals for the D.C. Circuit. That is really our third most liberal federal appeals court currently. And they ruled against the president as well on this question of presidential immunity. And so the president asked the Supreme Court to review it. They did so. And that's how we got here. The first time ever that the U.S. Supreme Court had to confront any prosecution of a current or former president of the United States, and with it, one issue to be resolved right out of the gate is what level of official immunity does the president have? Because there are different types of official immunity for people who serve in the government. Some of it is absolute immunity. Some of it is what we call qualified immunity. Official immunity comes in several forms. There's what's called sovereign immunity, when you actually represent the government itself. And then there are different types of official immunity when you are being sued in your official capacity for things pertaining to your official acts related to your office. And so that kind of sets the table to how this issue got here, with the justices being asked to say, how do all those principles apply to a current or former head of state and head of government?
Okay. It says here, the court holds that a former president, Donald Trump, has absolute immunity for his core constitutional powers. So one of the complaints against Trump is that he and his co-conspirators attempted to enlist the vice president, Mike Pence, to use his ceremonial role at the January 6th certification proceedings to fraudulently alter the election results. That was the claim. So the idea was that he met with Pence, and Trump pressured Pence to send back some of the votes to the state legislatures for review. And I guess people on the left thought that was a crime or something.
Well, let's take one step further back. What the Supreme Court said is that every act that a president takes during this time in office, you can put in one of three buckets. One is core functions. Second is non-core or non-constitutional, non-core in terms of his constitutional duties, non-core official acts. And then third are private acts. And so in that first category, those are things for which a president is absolutely immune. You don't even need to have a hearing about it. And they raise in the opinion, for example, when the president talked with his attorney general, they say the ability of a president to speak to a cabinet officer, or to get legal advice, like from his attorney general, that goes to his core constitutional duties. That is an inherent part of the discharge of his office. And so that goes into a narrow bucket of items for which there's not even a presumption of immunity. It is absolute, and it's not even for judicial review at all. That anything in that category you can just take right off the gate. They say then on the other end, you would have things that are purely private acts. Like if a president were just to, a president can walk down the street like any other human being. He's surrounded by Secret Service when he does it. But if a president were walking down the street in Washington, D.C. or out on a trip, and just all of a sudden he doesn't like the way some guy's looking at him, so he just punches him in the mouth, okay? There would be no immunity for that. That is a private act. The guy who did it was president, but he wasn't doing something. He wasn't taking a presidential action when he was doing it. He was using the fist at the end of his arm, just like any other human being would be, and he wouldn't be immune from prosecution. Now, he might not be actively prosecuted while he is in office, but he would be subject to being charged to assault or battery, however that crime is defined under the laws of the state where it happened, upon his leaving office. Then you have this middle category, these official acts. So in the court defined that as anything within the outermost perimeter of his official duties. And he says for anything in that zone, which would be many of the facts here, the president is, and this is all new now, it's new, but it's not. It's been a background assumption in law for 200 years. So when the left is like, oh, the court just invented this, no, this is what scholars and senators and this is the way it's always been discussed over the past 200 years. It's just no one ever tried to actually charge a president before, so there's never been an opening to have a court decision on any of this. But this is all just codifying what the consensus or majority of scholars over the past 2 centuries have believed, and that is a president is presumptively immune. So the default for the court is that, okay, for whatever that act is, the president is immune. What that means is, by making it a presumption, it means that the burden is not on the president to prove he's immune. The burden is on the prosecutor to show that he's not. And that for each of those acts, the prosecutor must show, first of all, that it was not actually an official act. He has to persuade the court of that. If he can't do that, then the president remains immune. And secondly, that as an official act, that to prosecute a former president for this would not intrude upon the authority or the functions of the executive branch of government. And that if the prosecutor can't do that, then the president remains immune from it, whether or not it would cross a legal line, because that's where all immunity comes in, like spousal immunity. Like if you break the law, Mike Slater, and they want to put your wife on the stand to ask you, hey, what did he tell you about this stuff? It's your lawyer would object and say marital privilege, meaning whether he broke the law or not is irrelevant. The court cannot invade your marriage and force your wife to testify against you. And you have attorney-client privilege, and then you have all of these different types of official immunity, and this would be one of those, to say that anything that's left on that middle category, if the prosecutor can't overcome that presumption by checking the boxes I just described, it's just off the table. A president is immune from prosecution.